Yes, Mr. Fallon, good morning.
Good morning, Chief Justice, and good morning, Your Honors. Richard J. Fallon for the defendant appellant, Euclides Ortiz. Before I address the important issue of the expert witness, Mr. LeBlanc, I want to address another issue I think is important, namely the failure to object to the hearsay statement of the daughter, Miss Romero, to her mother, the victim, Miss Tejeda, that the victim said she was going to the restaurant to pick up Mr. Ortiz. This was a significant statement because it was a report that the defendant, Mr. Ortiz, was the last person reported to see the victim alive. So it was extremely prejudicial. The Commonwealth argues that this comes under the hearsay exception of present intention to act. But the Commonwealth does not address or acknowledge the fact that there are two statements here, two distinct statements. The first statement of Ms. Tejeda, that she was going to the restaurant, nobody really cares about it. The jury didn't care if she was going to the restaurant or a bowling alley. The second statement, that the victim saying that the defendant told her that he would be there, that's the statement that was so significant, and that's the statement that does not come under the exception because it's about the actions of another person, the actions of someone other than the speaker, Your Honor. And I just want to say there are two cases that are notably...
I mean, I gather she said that she was going to the restaurant supposedly to pick up Mr. Ortiz.
Exactly, Your Honor.
If it had been phrased, I'm going to go pick up Mr. Ortiz at the restaurant, would it be fundamentally different in terms of the
No, not
hearsay?
at all. But the key thing is that it is a sort of a hidden statement, not that hidden, that Mr. Ortiz told her he'd be at the restaurant. And the Shepard versus United States case is this case almost extremely like it. And I'll quote the language at 104. In that case, it was a statement that the woman said she was poisoned by her husband. But the Supreme Court says, the government, and I quote, used the declarations as proof of an act committed by someone else. That's the key point. And right at the end of that decision, they write, and I quote, what is even more important, it spoke to a past act, and more than that, to an act by someone not the speaker.
Was that a declaration of present intent? Was that the evidentiary issue in that case?
It was state of mind, which is really the same thing here, present intent, state of mind. They're really present intention act is a kind of state of mind. But the whole point, Your Honor, and I suggest it's the same thing, and I'm not going to belabor it, because it's about really a past act, Mr. Ortiz telling her something, and more than that, someone not the speaker, i.e. that Mr. Ortiz was going to be.
Well, what if she had driven him to the restaurant earlier and was going to go back and pick him up, apart from any conversation that he may have said to her? The
whole question is, how do we get that in? And it was hearsay. It wasn't double hearsay. I was wrong saying it's double hearsay, but it was hearsay because it was the daughter saying. Now, if Mr. Ortiz had told the daughter he was going to be in the restaurant, that'd be different because, of course, he's the defendant. But it's really the mother saying that, it's the daughter saying that the mother said that Mr. Ortiz said something. That's really
It's not the mother saying, I'm going to the restaurant because I believe that my husband is there?
Well, how did she, I mean, that's why it's a little, how does she believe he's there?
What difference does it make?
Because she
That's
believes
why
he's
she's
there because
going.
he told her she's there. And that's the problem. That's the problem. It's not her state. If it was, the mother said she's going to the restaurant. That's her present intention to act. Nobody would care.
Are you suggesting that that's because it's one possible scenario, we have to assume that's the one? Because, I mean, there are certainly others. She could have heard about the pregnancy and said, I'm going to pick you up. I'm going to talk about this, so be there. And
right.
So that doesn't matter to you whether, or even if she was just thinking that.
It doesn't matter because it's all about the actions of Mr. Ortiz. And that's the whole reason it's relevant. It's not relevant because it went to a restaurant. Like I said, we don't care if it's a bowling alley or a football game. It's relevant because it's the actions of Mr. Ortiz. That's it. I don't have to go further because it's the action. And right at the end of the Shepard case, they say that. Well, let's turn to the expert witness, Mr. LeBlanc. And the best shorthand way to describe this is the word used in the 1999 District Court, D.C. District Court case. And I quote, inconceivable, end quote. Put more conceptually, my argument is that the first bedrock criterion for allowing an expert was not met, so it was an abuse of discretion. And that first criterion, mentioned in a number of your cases, is namely whether the expert is, quote, able to assist the jury, end quote, or, in the words of Professor Wigmore, whether on this subject can a jury receive from this person appreciable help.
Can you just clarify, did
Sure.
he testify as an expert or as a person describing the chain of custody?
Both. And my key argument, and maybe I didn't make it clear here, but I'll make it very clear. I'm not arguing, trial counsel argued both, but I'm not at all arguing that Mr. LeBlanc should have been excluded as a lay or percipient testimony for what he did and for chain of custody and for having, having took photographs or identifying. And that's not my argument at all. I would not argue. As I would say.
Could you explain to me, though, how did he come to testify as the expert? Did the Commonwealth propose to call another expert?
Yes. What happened was
the trial counsel objected to
a
that?
weird concatenation of facts. After the jury empanelment, I guess it was Friday, over the weekend, it turns out the assistant DA realized that even though Mr. LeBlanc had said the downstairs doorknob, which is the key one in the room where the killing happened, all the blood, he said the downstairs doorknob I can identify the thumbprint, and upstairs, which is upper stairs and everything, there's nothing that can be identified. The expert, Mr. Kilgore from the Smith Associates, it turns out, and this is partly Mr. LeBlanc's fault, not very good, but anyhow, we can tell that he said the opposite. He said he could identify a thumbprint upstairs, but he couldn't identify the thumbprint downstairs from the doorknobs. He didn't. This is all. He looked at the doorknobs, and so, apparently defense counsel knew this, but the prosecutor just found out over the weekend. So, when it got Wednesday, the day 4 of trial, he had been trying to get in touch. This was why he suggested to use LeBlanc. He wasn't planning. In fact, there was an assented to motion saying the motion for protective order, so we wouldn't get into the details of the Smith report, saying he wasn't going to call him. And then on day 4, and this is the key thing here, day 4, the trial counsel specifically said it was based on the Ron Smith report that he wasn't going to call LeBlanc. So that's very clear. And, of course, that Smith report, even though the trial counsel used language like, I think the conclusion he perjured himself is overstating a bit.
Was Mr. LeBlanc the only witness who had examined this fingerprint and could testify about it? I guess that's what I'm getting at.
No. But in fact, here's again what happened. And if you want, we've talked.
LeBlanc testified that the fingerprint, his fingerprint analysis had been verified by his partner, right?
Yes. I forget that, but he may well have said that. Okay. Yeah, it's hearsay, but But the problem is, there's no way he should have been allowed to testify. It was just a complete abuse of discretion.
Now, during the course of his testimony, did he actually show the jury the fingerprints? Or
they had the doorknob was in evidence.
Right, but did he
And there was a
blow up?
picture
Did
of
he
a
blow
doorknob.
up the fingerprints and show the
I don't believe
latent
so, Your
compared
Honor.
to the known?
Maybe the prosecutor has a better man. I don't believe so. I believe he just identified. My memory, he just identified that this is.
So the jury had no ability to look at what he was doing and say that makes sense.
Yeah,
as
and
far
I
as you
don't
know.
know that that would make a difference, because then you're relying on the jury here, Your Honor. I mean, the key point, if this is simply credibility, I know I lose. There's the Roberia case. But my suggestion is that there's a very important principle here and very important legal question, and that is whether if an expert is technically qualified, is that all it means? Is that all you have to look at to assist the jury? And I argue, and I think it's reasonable, and it never comes up because, as we all know, you can pick your friends, but you can't pick your relatives. You can pick your experts. And
Well,
so,
if LeBlanc had not been the expert who
Yes.
had testified on this particular opinion, you're not contending that some other expert couldn't have been called to testify
oh,
on
no,
that?
not at all. And Kilgore could
So expert testimony would have been of assistance to the jury.
Of course, Your Honor, but we can't do.
So this comes down to, I mean, and you're not challenging that he didn't undergo the requisite training for fingerprint analysis?
No, not at all. That's not the issue.
The issue here is that you're saying, I take it, that he was disqualified
Exactly.
by virtue of his having
exactly.
lied in one previous case.
Yes, and sending the guy to 20 years. Well, no, disqualified because the Commonwealth didn't trust him. That's my point. No, not that, and that's important. I'm glad you brought that up. My whole point is at least one party has to trust him, or he can't be of assistance. And the Commonwealth didn't trust them. I mean, they brought, as we know from the law review article in the Commonwealth brief, they brought criminal charges against him. I mean, the Commonwealth in its brief says, well, it's theoretically possible he wasn't intentionally lying, but it wasn't really the position. They brought criminal charges against him.
But respectfully, the Commonwealth all the time does that, not in the expert context, but with regard to cooperating witnesses. They very, very often call people to the stand who they have prosecuted, sometimes for perjury.
Exactly, Your Honor, and that's why it's so different. That's why I'm not arguing he shouldn't have been allowed to serve as a lay witness. I'm arguing he shouldn't have been allowed to serve as an expert. And there's a diabolical problem with that, too, you may realize, and I believe I've argued in my brief, is that his being allowed to serve as an expert witness kind of vouched for his precipient witness. I mean, you think of it, a juror could have said, well, they can't really think that he's that bad or a liar because they called him as an expert.
Yeah, but this is sort of a defense lawyer's dream, isn't it? Getting somebody up as an expert expert witness who's been administratively suspended. I mean, they're going to have a field day. This is exactly the kind of witness you want as an expert.
And they did, right?
Well, they didn't, of course, get in the fact that the unanimous four-member found that he was intentionally lied. But here's why that isn't correct. It isn't the dream. For example, think of let's assume Kilgore showed up and testified. Because they could have called him, he identified, there was no reason. And defense counsel asked Mr. Kilgore, are you familiar with the Smith report and Mr. LeBlanc? And, he probably was because he was part of Smith Associates, though he was not on the panel. And he says, given your knowledge, would you were given all this material by, Mr. LeBlanc did all the work. Given all that, can you trust any of the stuff you were given to serve, can you trust the facts? And that could well have been very powerful. And that's why I argue we cannot, as the Commonwealth wants you to do, say, well, some other theoretical case, it would have been okay, because otherwise we could have, like on TV they do, have the young, good-looking presenters get up on stand and then say, well, it doesn't matter because we could have had somebody else. Again, as the McGraw case, what's very prejudicial is defense should get the right to cross-examine a qualified witness. And that's the key issue here. And of course, like I said, it never comes up as far as I can tell. And that's why, I know I'm relying on the word inconceivable, but I agree, it's inconceivable.
So what is the principle here? That if a expert is found to have lied at some point previously, the judge is barred from allowing that expert to testify, even if the judge thinks that the testimony today is reliable?
No, Your Honor. I say at least one party has to, even if it's just the judge, has to trust the expert. Has to trust the expert.
Okay, but the Commonwealth, I assume, will say we didn't particularly like this guy. We would have loved to call somebody else, but we trusted this finding that the fingerprints matched, in part because we had three other people who looked at the fingerprints independently and said it matched.
Yeah.
So we're comfortable with this particular finding. We would prefer to have somebody a bit less, with less baggage as the messenger.
Right.
Why is that a problem?
But here, you can see the problem with that right away. Because again, as I'm arguing, and the same with the other we got to defense should have a right to cross-examine the person they're going to use. What the Commonwealth is saying, it doesn't matter because we could have had somebody else. Well, no coulda, woulda, shouldas. In this case, if there's an abuse of discretion in bringing an expert witness, you say whether it's a substantial likelihood of miscarriage of justice. You don't think of what the Commonwealth is saying is some hypothetical other trial with a different expert would have been okay. And when I'm saying we don't know what would have happened, for example, here's the other key thing. They called LeBlanc rather than Kilgore because they thought he was going to be a better witness for them. Otherwise, they could have called Kilgore because he could have testified. And in fact, it's kind of odd. Nobody said it wasn't a photograph, but you know, the thought was, well, maybe it degraded, and that's why, you know, in 2005, Kilgore couldn't identify the one downstairs. But then in 2006, during the trial, this Miss Hannaford, the Boston police person, said she could identify the downstairs thumbprint. So we have, it's not like all the experts are saying exactly the same thing. I mean,
I thought at the end of the day they all were.
Well,
Hannaford, Silva, and maybe I'm misunderstanding the Commonwealth's brief, but Kilgore also,
No,
at least on the day that LeBlanc testified, compared the bloody fingerprint from the photograph to the defendant's car, determined it was a match. I don't know. I didn't see that Kilgore at the end of the day had a different view.
well, he didn't. He originally said well, his different view was that he couldn't identify when given the doorknob downstairs. He couldn't identify a fingerprint. But then he was sent photos during trial, you know, right in that day of February 1st. And he identified Matt. Now, we kind of assume those photos are probably the downstairs doorknob. But, you know, we don't know.
But all of this sort of and I know that at least, again, the Commonwealth brief suggests that they proposed to call Hannaford and Silva, but the judge said they weren't on the witness list, and therefore...
Right, exactly. That's exactly. They could have called Kilgore. It's not like, I mean, I was thinking of hypothetical.
And Kilgore was on the witness list?
Yes. Yeah, they always had planned to call him. That was the whole point. And it's kind of like I was thinking of hypotheticals. What if you had the expert forger in prison who was the only expert on this particular, you know, whatever it is?
And the judge said, we're not going to let you call these two witnesses because they're not on the witness list, even though they are experts as well.
Yeah, but let's say let's assume hypothetically he's the only expert in the world. I would say, you know, and that would be kind of interesting, difficult thing. I would say in the end, yes, you can call him. However, what I would say, if he had been if we add another fact, if recently he had, you know, lied in a case and sent an innocent man to a 20-year sentence, I would say no. Nobody, and the party column didn't trust him. I'd say no, that's not a qualified expert. And, Your Honor, I noticed
Well, to get back to Justice Gantz's point, I mean, with all of these other experts now confirming that they agreed, doesn't that sort of, you're saying the Commonwealth had no confidence in the result. Well, I suggest that they confirmed that the result was accurate and therefore did have confidence.
We're still not sure of, we're still not 100% sure of Kilgore because we don't really, I think, and I don't think, we don't really know that the photographs are, you know, we kind of think, and it's kind of reasonable to think because LeBlanc only testified to those photographs. We don't really know those. And I've never suggested this, but I talked to the prosecutor. If it would help, we'd do a joint 16L letter to try to make clear some of this stuff, which obviously confused me during the thing. But we're not sure that they're all, nobody said it wasn't his photograph. That's clear. There's nobody there. What, if I can have one last little comment on the closing argument, a sort of attack on because I was thinking about on the defense counsel saying it was lawyer talk and all these questions about illicit relations over and over again to female witness. Now, this court obviously often will say there was no objection, and so that kind of indicates that it's not. In this case, it was almost like the prosecutor goading defense counsel objecting, because can you think of the catch-22 he's in? He's being attacked, and then prosecutor didn't object to his closing, and then if he comes up objects to closing, stops the prosecutor. That's lawyer talk, isn't it? That's kind of being a sadistic bully. So I guess one point I want to make on that is that I would suggest that with regard to no objection, that the defense counsel on that improper attack was put in an untenable position, so you should not use the lack of objection there as an indication.
Trials and tribulations of trial counsel. These decisions have to be made.
Exactly, Your Honor, exactly. If you have no further questions, thank you. I'll sit down.
Thank you.
Thanks so much.
May it please the Court, Joseph Ditkoff for the Commonwealth. With me is Edmund Zabin. He was the trial prosecutor in this case. Your Honors, to answer Justice Cordy's question, this was not, of course, the intent of the Commonwealth going to this trial to have Officer LeBlanc testify as an expert. He had to testify to chain of custody. He was the only one who could say what doorknob was what. But there were no less than 10 fingerprint experts who had, by the end of this trial, had confirmed that the lower doorknob matched the left thumbprint of Euclides Ortiz. If you go from Commonwealth's Appendix 1 to 8, you'll see Officer Fontaine, Sergeant Silva, Sergeant Forbes, Sergeant Detective Strotter, Director Hannaford, Criminalist Ione Truta, John Kilgore, Ron Smith, Jason Presley, and Bob Garrett, also the Ron Smith and Associates. What happened was there are two doorknobs, and what Officer LeBlanc did is he matched the downstairs doorknob to the left thumbprint of Euclides Ortiz. And then everything was sent, including both doorknobs, which are not labeled in any way, shape, or form. Again, the chain of custody problem. And John Kilgore matches a doorknob to the left thumbprint of Euclides Ortiz. So Mr. Zabin thinks, so I've got the exact same match from John Kilgore, and that's how I'm going to present it. Now, it turns out on the Friday, right after the first day of trial, the day of impanelment, he finds out that it's actually the wrong doorknob once he's talked to LeBlanc and finds out exactly which doorknob is which, and that he hasn't matched the downstairs doorknob. And so he immediately goes to the judge on the second day of trial and says, I want to bring in, Sergeant Silva or Director Hannaford. And the defense vociferously objects to adding this. And the judge decides it wasn't on the witness list, so they can't be in. Now, John Kilgore is on the witness list. Why don't you call John Kilgore for this match? Because by February 1st, 2006, and you'll see this on page 6 of my appendix, he has made the match from the photo and Officer Blank testified he took a picture of the print on the downstairs doorknob, and he matches the photo to Euclides Ortiz's left fingerprint. And the reason is it appeared to the Commonwealth, and Mr. Zabin said to the judge, and this is on the volume 6 of the transcript at the beginning of that day, that I don't believe you're going to let me elicit that opinion from John Kilgore. Sure, he can do the other opinion, but not that opinion, because that opinion wasn't disclosed prior to trial. And what Judge Quinlan says is, she refuses to tell him, and she says, I like to have the element of surprise. You can imagine the disaster if you call John Kilgore, and he's not allowed by the judge, which would seem consistent with her focus on pretrial discovery, not allowed to actually elicit the match. We would have much preferred to have anyone else do this match, but as the trial develops, the trial judge wouldn't allow us to have anyone but LeBlanc do it, and so we had to have LeBlanc as the expert and just get crushed, testified and crossed that he was branded, that he wasn't allowed to go in the latent print room at all, just terrible stuff. And then again, when the defense counsel questioned Sergeant Detective Coleman, who was the lead investigator, about Officer LeBlanc and about how he'd been put on administrative leave. It was just terrible. And as it developed, so by the end of the case, the Commonwealth has, not the proverbial, but the literal bloody fingerprint, and is asking the jury to disregard it. The prosecutor said, go through your notebooks, notepads, take out every single solitary reference to that fingerprint, and throw it in the trash can.
Well, he didn't say to disregard it. He said you could disregard it and still convict, didn't he?
Oh, absolutely. Then he goes on to,
Okay.
you still
Yeah,
have the DNA.
okay.
DNA being in the watch,
Right,
there's blood in
right.
the wristband. You got the confession to the godmother. You have the conscience of guilt. 3 times he's caught hiding in a closet or an armoire. So there's an ocean of evidence in this case. So, yeah, we can get rid of the fingerprint. And really, this fingerprint wound up not helping the Commonwealth's case. It should have if we had gotten one of the experts that we wanted to. But as it developed, it just became an embarrassment to the Commonwealth.
So what is the standard we are to apply with regard to reliability? I mean, is reliability to depend at least in part or on the credibility of the witness? Does a perjured expert who arguably has committed perjury, can that person be viewed as reliable enough to pass Daubert-Lanigan?
Definitely not. The Roberio case says the judge is not supposed to consider the credibility of the expert. They're supposed to consider his qualifications, whether he has a reliable process, whether it's applied in a reasonable manner, whether it's the kind of data experts rely on, whether the opinion itself will assist the jury, none of which are challenged. His qualifications aren't challenged. At John Kilgore, people say he's highly qualified to make difficult matches, and this is the normal process that is applied. The credibility not only isn't part of the Lanigan-Barboza test, and I know Your Honor wrote Barboza, but the Ribeiro case says the judge isn't supposed to consider the credibility. You can imagine that. I don't see any way you
Right,
limit
well, I mean,
it to one
credibility is
side.
a little bit different in terms of whether or not I credit an expert. Obviously, in a case where there's expert on either side, you're not going to credit both, but they both may be allowed to testify. But this is a little bit more than that. This is somebody who supposedly knew something was wrong and affirmatively concealed it from a jury, which resulted arguably in a person being wrongfully convicted. I mean, that's more than a typical issue of credibility that an expert is generally faced with.
I mean, the accusation is a serious attack on his credibility, but that's not an accusation that we think is true. And you ask yourself, what would the judge have to do? I mean, she would have had to hold a trial on the Cowens case, a trial that never happened because he was not indicted for what he did in that case. And that's certainly the Kilgore report, the Ron Smith
But a
report.
judge doesn't need a conviction to be able to make a finding as to past conduct, does she?
No, she doesn't, but you can't just take one report and say, okay, therefore it's proved. I mean, she would have had to go through and hold a little trial on what he did and how he made this mistake. But it's fairly well established that a prior instance of even purposeful falsity doesn't keep someone from being testifying. Even a conviction of perjury doesn't disqualify someone from being a witness. And why should that apply to an expert? There's going to be a time where a defense wants to bring in an expert that the Commonwealth can say, oh, well, I can show that they've purposely lied on some prior time. And not only do I not think that's a valid legal grounds for it to be excluded, but you can imagine how hard that would be to actually implement in a trial thing, where instead have the witness testify and let that witness be crossed, as this witness was crossed. Now, of course, we didn't want any of this stuff. We wanted to have different experts, and in the end, this fingerprint just became a liability for the Commonwealth. But as far as the test, that really can't be part of the test, Your Honor. I mean, how often do you see a transcript where one of the Commonwealth's expert witnesses can be crossed the way this witness was crossed? It's certainly not something that we wanted, and certainly not something that that's good for the Commonwealth. But as far as a gatekeeper function of the judge under Lanigan-Barboza, I don't see how that can be an element of that. Beyond the fingerprint, I know it's confusing as to exactly what was ID'd because of the two fingerprints and the lack of any, the two doorknobs and the lack of any specification. But there isn't any evidence, unlike my brother said, that LeBlanc couldn't ID the upstairs doorknob. There's no indication that he ever even tried to do that. So we don't know what would have happened with that. Unless there's any more questions about the fingerprint, I'll just touch briefly on the hearsay issue. The testimony on page 44 of Volume 2, and I think Justice Cordy may have quoted it exactly, is she was going to a restaurant supposedly to pick up Euclides. Now, it's certainly the case that her intent, she has two intents there. She intends to go to a restaurant. She intends to pick up her husband. But that's what it comes into, that she intends to go pick up her husband, and then she goes to try to go pick up her husband. Whether she wound up picking him up at the restaurant or at his home, which was across the, which was may have been across the street or may have been one of the Chelsea places. It was a little unclear exactly where he spent most of his time. That's what it comes into, that she intends to go pick him up, and that's why it has its mild relevance. But how, in fact, she determined that he might be at a restaurant, or even if she determined he was at a restaurant, the point was that she intended to go pick him up for whatever reason, and we don't know what the reason was. And that is directly in the statement of present intent to act. You look at the Ferrara case, where the statement was, I'm going to go shoot a cop. And there wasn't any issue of, well, how would the person know where a cop would be, where to find a cop? That was his intent, and he put it into action. And that was admissible under the exception. Same thing here. As far as the closing argument, all I'd say is that the defense did, in fact, one, make the accusation based on nothing in this case, the implicit accusation that it was the victim's daughter and son-in-law who were involved in the murder, and the prosecutor is entitled to call him on that. And as far as the sexual relationship, asks Rivera over and over again, even after she's denied it, is there a sexual relationship? Even asked her son whether there was a sexual relationship, in an attempt to insinuate by the questions what wasn't in evidence. And the prosecutor is allowed to comment on what the jury witnesses of the defense tactics. And if there's no further questions, I'd be happy to rest on my brief. Thank you, Your
All right,
Honors.
thank you.